This time and date set for sentencing for the defendant in this matter is Weisenbach. Where's your client?
Thank you, Your Honor. My client is not with me at this point. I received a call and I have since received a text message from his wife that he is at the hospital.
Mr. Tresco, do you have any response?
Your Honor, the people tried to meet with Mr. Kaufman before the case was filed and have come to resolve this pre-charge. Every time we set up a meeting with Mr. Kaufman, he canceled the meeting the morning of because he was in the hospital. This seems to be the game that he plays to avoid responsibility, and the people are requesting a bench warrant.
Ms. Weisenbach, any response?
I have no reason to disbelieve his wife. There is nothing in this record or any reason whatsoever to doubt her truthfulness with regards to the matter. If that's where he is, that's where he is.
All right. Well, for the record, we did have a brief conversation off the record regarding this matter. The court was advised that the defendant is unavailable, and at least at this point, and the Attorney General's office has placed on the record exactly what was stated during our conversation. And as a result of that, this matter is scheduled for 9 a.m. The defendant is not here. He has until 9:30 this morning to appear. If he fails to appear in this matter, the court is going to issue a bench warrant for his arrest, body bond. And that was discussed as well in chambers as well, Ms. Weisenbach.
I just want to let the court know that is agreed. I want to let the court know that I could probably be available until 11 o'clock. I have 2 other matters, and I do need to meet with an individual whom I am substituting for a different attorney, so that would take some time. So I can be here until 11 o'clock.
All right.
And Your Honor, if I may, if the court would provide a paper copy of the warrant at 9:30, I have my special agent here in person who plans to go directly and arrest Mr. Kaufman.
Very well. We'll try to get that done as quickly as possible. This matter of people of the state of Michigan versus Terry Alvin Kaufman, the defendant, by way of history, on March 16th of this year, pled no contest to 1 count of criminal enterprise, 2 counts of embezzlement, $20,000 and $50,000, 5 counts of embezzlement, $1,000 to $20,000, and funeral contract conversion, 31 counts.
Mr. Kaufman is being sentenced today for stealing $192,000, although much, much more was stolen. We believe, regardless of the amount that Mr. Kaufman spent on lottery tickets, whether it be $192,000 or $1.1 million, I believe it's important for the court to know essentially what his scheme was funding, which was his addiction to lottery tickets.
Ms. Weisenbach, final comments.
It's inappropriate. It doesn't belong in the PSI. We do not ever chase where the money went. We do not chase that when we consider larceny cases. We do not consider it in other types of cases. So restitution, et cetera. Restitution has been handled and agreed upon. Victims have been listed and agreed upon. It's irrelevant, and I think it's inappropriate.
I think it's important to understanding what efforts the court would have in getting the money back. So I think it's very relevant. Objection is respectfully denied, Ms. Weisenbach. Anything else for the record?
Now with regards to the PSI.
Your Honor, I believe based on Mr. Kaufman's behavior this morning, that OV-19 should now be scored at 10 points. The OV-19 is not offense specific. Any behavior occurring up to sentencing can be scored under OV-19, and I believe that failing to appear for a sentencing hearing counts as 10 points for otherwise interfering with the administration of justice.
Ms. Weisenbach.
Thank you, Your Honor. This morning at approximately a little under an hour before we were to proceed with court, I received a phone call from Mrs. Kaufman that her husband had an injury and she was taking him to the ER. We had a brief conversation with regards to that. I asked her to keep me posted of his whereabouts. And I have paperwork in front of me that he was at McLaren Regional Hospital. I'm letting the court know, and I can present this to Your Honor, that he had suffered a concussion. I have this in front of me. He now is sitting in front of you with a concussion, having suffered this morning. There was no, as far as I can tell, except for comments made by the Attorney General that are out of the record for anything else, except just today. There is no information that I have that my client has attempted to not be in court. He has been at every court hearing. He has been at every meeting that I have asked him for. He has met with the investigators. He gave statements. They are in the PSI. And to say today that he was dodging today, his wife called me and said, this is what happened, what to do. And I told her to take him to the hospital. That is where he was. I have yet to give any disparaging comments to this court to mislead this court or anything to that effect. And my client his wife has told me where he is. We've known where he is. He went from home to a hospital and now he's here. I would ask the court to disregard any request made today with regards to with regards to sentencing guidelines. And they were due a week ago or more. So I understand the position is that somehow it's an emergency to them today. If not, he was in the hospital and I can approach with this documentation.
That's final argument.
Your Honor, regardless of whether the reason he was at the hospital, the fact is the court signed a warrant. My special agent went to the hospital to try to arrest Mr. Kaufman. Mr. Kaufman had already been discharged and had gone home. Had Mr. Kaufman been discharged and come to this court, I might not be making this argument, but the fact is he chose to go home and he was arrested at home and brought here in handcuffs.
All right.
And with regard to the time frame, I don't know how I could have possibly made this argument a week ago since that it happened 2 hours ago.
Also at 9:35, his wife stated that he was discharged. She sent me a screenshot of the paperwork and I texted her back that you have to bring him to court. Judge had issued a bench warrant. So all of this was going on at the same time. I had told her to bring him here, but moments later, then she said, okay, 10 minutes later at 9:55, she said that the sheriff and a prosecutor came and picked him up and they're leaving. So no one's been dodging anything or avoiding anything. His wife had been in contact with me. He was having a concussion. He wasn't in a position to make any specific actions with regards to his behaviors today. She took him to the hospital. She was going to bring him here. They just got there first. That's the only difference. She has been very compliant, very appropriate this whole time. There's nothing to be held against her.
Well, she's not the one before the court, her husband.
Understood, but I want you to be aware of who I was communicating with this morning. My client was in no position to communicate with me.
Sentencing guidelines can be considered up until the time of sentencing. Obviously, if there's an objection relative to what probation department had scored, based upon all the circumstances, the court is going to continue with sentencing with the original guidelines for OV-19 respectfully is denied. Ms. Weisenbach, is there anything you'd like to say on behalf of the client before the court imposes sentence?
I believe that at this point, I am required to ask this court to consider an adjournment in light of the fact that my client is sitting here with a concussion that is medically documented. I can approach the court with this documentation.
Show it to Mr. Tresville first. That's going to give the opportunity to review the document.
I have, Your Honor.
Your position, sir.
Your Honor, I don't see what the point of an adjournment is at this point. Mr. Kaufman has admitted his crimes. He's here to be sentenced today. He'll get excellent medical care in the Department of Corrections.
There's no indication alleged fall occurred. Nothing. Is there anything in the medical documentation to indicate that the defendant is unable to understand what's going on? The head injury, alleged head injury is traumatic enough where he wouldn't appreciate what's going on today?
It's inherent in having a concussion.
Your Honor, I strongly disagree. And I believe that Mr. Kaufman, Ms. Weisenbach can voir dire her client if that is in fact the case, but I would ask the court to also take testimony to the client that he does not understand what's going on today before the court considers an adjournment.
Raise your right hand, sir.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Ms. Weisenbach.
You had a head injury?
Well, he said I have a hematoma in the back of my head.
Okay. Are you able to hear and understand everything that's happened today?
Yes.
Do you feel that the injury to your head has caused you any issues with regards to understanding the judge?
No.
Okay. I have nothing further, Your Honor.
Any questions?
Don't see any basis to grant an adjournment.
Based upon this court testimony, the defendant understands what is proceeding. I'll hand you this. Well, is there anything you'd like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. Yes. So available were the victim letters. I want this court and I want everyone to understand I read every single letter. I read every single letter, every heartfelt thought, everything that was in there. I understand their position. With all due respect to the victims, my comments are never meant to be disrespectful. But there are two sides, and today is the side of Terry Kaufman. He comes before this court, 72 years old, with actually no criminal record. Married, 3 children, high school diploma, advanced education, and just about 50 years of providing compassionate funeral service for many, many grieving families over many years. kind, considerate, soft-spoken, polite, respectful, and for, yes, many years, well-respected citizen businessman. In these letters, I know you've read them too. There are stories of kindness, seeing that he had gone above and beyond what was necessary in his advanced years, shoveling out a driveway just so that a funeral could take place. As he had stated in his comments during the investigation, this money was not sent into the escrow. It was used to back into the business, especially payroll. There were other people on the payroll, other employees. Yes, he was an employee. There were slow times. There were lean years, and the doors could have closed. The doors were kept open because of that cycle of money coming in. It's not a secret that funeral business has been changing. They are struggling. There has been, in my area where I live, a murder, Elkton, Caseville, Pigeon, Cass City. And I tried to look it up this morning, but I think that Seaboyne has had to merge as well. Coffins would have closed many years ago if it hadn't been for this particular income. Provided this service all these years for these families. During this time, he was not living extravagantly. There's a lot of people who know him, who know how he lived. There are a lot of people who don't. There are, have been made comments outside of this court with regards to living an extravagant life. He lives in a modest ranch house, and the court has seen in the PSI there's still a mortgage. And in return for living modestly and keeping a business open, those who had passed were given their funerals. It didn't matter if it was at that funeral home or if it was at a different one. The money went to wherever the funeral was held. And this actually happened in the case that triggered this situation. The money was always sent and it was covered. Credit was given, and he honored the word to the people who he had told them that it would be okay. And he always expected and planned on honoring that. I could not ask for a better client when it came to appropriateness towards me. He has been polite, respectful, kind, generous, and compassionate. He understood my position. He understood the role I served. He was always appropriate, always on time, always came to the meetings I asked for. As you can read in the PSI, he is resigned and accepting of what is going to happen. He is aware, and he is fully prepared to accept the sentence from Your Honor. With that being said, again, I'd like to remind everyone there's two sides. There was a business that kept going for the people of this community. It was not exactly the way it's supposed to be. I get that. So does he. There's just always two sides. I appreciate Your Honor and everyone's understanding of that. Thank you.
Does your client wish to address the court in light of the no contest?
Also, in light of the lawsuit that has been filed, no.
Very well.
Thank you, Your Honor.
Mr. Tresco, anything on behalf of the people, and this is a victim's rights case.
Yes, Your Honor. Before I make my argument, I would like Ms. Bond to address the court on behalf of her wards, the 55 victims named.
Your Honor, I represent 55 people who have been taken advantage of by Mr. Kaufman. These people are either illegally incapacitated or developmentally disabled without the ability to care for themselves. Some of them do not have the ability to understand what has happened to them. These people do not have much. The little they do have is carefully budgeted and spent so that they may live comfortably, and so they are cared for. The money in the prepaid burials was mostly supplemented by the stipends sent out during COVID. That money was carefully done. That money will never be replaced. Some of these individuals will never have anything extra to pay for a burial or put into another prepaid again. That is why the careful planning was done.
Your Honor, Mr. Kaufman argues for leniency based on his lack of criminal activity. Mr. Kaufman admitted to 39 felonies, including criminal enterprise with predicates spanning the last 10 years. So it's not for lack of trying that Mr. Kaufman has no criminal record. It's simply that it took a while for him to get caught. He argues for leniency based on being a respected member of the community, but the fact is he abused that respect in his position in this community to steal from the members of this community. He claims he did this to keep the business afloat, but his bank account records showed that he paid himself $1.5 million in the last 10 years. That wasn't money kept in the business. That was money that was moved to his accounts, including secret bank accounts his wife didn't know about.
Your Honor, I'm going to object. None of this is in the record. And I would also like to point out that as of yet, my client has not asked for any leniency, but in fact was ready to plead 3 or 4 proceedings back, but the Attorney General's office wasn't prepared. My client wants this record to be clear. He never wanted to ever come before this court and say not guilty. He never wanted a trial, and he hasn't asked for leniency. I would ask that the pre-prepared speech that's maybe cookie cut for every other case be tailored to exactly what's going on today. My client did not ask for leniency. My client isn't dodging coming to court. And anything extraneous that's not inside this record, I think is inappropriate with regards to it being argument, PSI, whatever. Thank you.
Noted for the record. May proceed.
Thank you, Your Honor. He also claims that, again, if someone came to him for a funeral, even though the money wasn't escrowed, even though the money was gone, he still did the funeral. And of course he did, because the minute he misses a funeral, the jig is up and he's caught. And that's what happened. Somebody else went to have a funeral at a different funeral home, and that funeral home found out the money was gone. And that's how this all came to light. Your Honor, the sentencing guidelines do not address the level of criminality that Mr. Kaufman engaged in. He scored 25 points on OB9 for having 20 victims. He had 55 victims. He scored 5 points on OB13 for 3 or more property crimes. He admitted to 38 property crimes. And he scored 10 points on OB16 for a loss of $20,000 or more. The loss was over $192,000. Based on all that, the people are asking the court to, at a minimum, sentence Mr. Kaufman to the top of his guidelines, with count 1 running consecutively to counts 2 through 8 for a total sentence of 108 months or 9 years. Thank you.
You're welcome. Court notes the number of individuals in the courtroom. I respect each and every one of you for being here. I respect any support that Mr. Kaufman may have received from family or friends as well here in the courtroom, because the court has to be right down the middle. And the court is going to be right down the middle, because at the end of the day, what may be investigated may be different than maybe what have been pled to, but regardless, we have a significant amount of activity that affected a lot of people. And a lot of people. A lot of people that put their faith and trust in this individual. And I couldn't imagine, considering my parents or anyone's parents or anyone planning for their future, because we all know when the good Lord says that's the day, that's the day. And the last thing we want to do is task our children or our other family members or friends to get through that. And that's why a lot of these individuals that appear before the court as victims planned for that. And they scrimped and scraped and used whatever they had to make sure that it made it easier for the family upon the death of the individual. And so just looking at some of these letters, for instance, I trusted him, so I wrote a check for $6,691. I'm angry that my prepaid funeral has been stolen. My children are upset that my funeral is now their responsibility. We gave him $15,990. He gave us papers showing that we had paid for both funerals, and we were all set. Both of us are in our 70s and 80s. We have difficulty with degenerative arthritis, walking and memory. Dealing with these issues only makes the stress worse. We trusted Mr. Kaufman as an upstanding member of the community. He assured me that the funds that I was giving him at the time of my death, the funeral home would arrange everything. All my children would have to do was grieve. I had a pre-need contract taken out in 2016 for $10,000 that was totally gone. From a 94-year-old individual. I considered making prepaid funeral arrangements for myself. At the time, I had the finances and wanted to spare my family from having to endure the burden of experiencing the difficult process. I can still remember a few days later, he delivered the contract to me with a cover letter, and on the envelope, he wrote, "You're all set." We are in our late 70s on a fixed income. Mr. Kaufman assured us that all would be handled properly and professionally. We've never met anyone of this nature before.
The matter before the court was the sentencing of Terry Elvin Kaufman in the people of the state of Michigan versus Terry Elvin Kaufman. The hearing did not begin smoothly. When the case was called, defense counsel informed the judge that her client was not present and that she had received both a phone call and a text message from his wife indicating that he had been taken to the hospital. The prosecution responded by telling the court that the people had attempted to meet with Kaufman on multiple occasions before the case was even filed in an effort to resolve it pre-charge, and that every time a meeting had been scheduled, Kaufman had canceled on the morning of the meeting, citing a hospital visit. The prosecution characterized this as a pattern of behavior designed to avoid responsibility and requested a bench warrant. Defense counsel pushed back, saying she had no reason to disbelieve the wife's account and that there was nothing in the record suggesting the wife was being untruthful. The judge acknowledged that a brief conversation had already taken place off the record and that everyone had been made aware of the situation. The court gave Kaufman until 9:30 that morning to appear, warning that if he failed to do so, a bench warrant would be issued for his arrest. The prosecution also requested that a paper copy of the warrant be prepared at 9:30. So that a special agent present in the courtroom could go directly to arrest Kaufman. When 9:30 came and Kaufman had not appeared, the court signed the warrant and the special agent went to the hospital to arrest him. However, by the time the agent arrived at the hospital, Kaufman had already been discharged. Rather than coming to the courthouse, he had gone home, and he was subsequently arrested at his home and brought to court in handcuffs. The prosecution made clear that while it may not have pressed the issue had Kaufman come directly to court after being discharged, the fact that he chose to go home rather than appear for his sentencing was significant. Defense counsel explained that she had been in contact with Kaufman's wife throughout the morning, and that the wife had told her she was going to bring him to court, but that before she could do so, the sheriff and the prosecutor had arrived and taken him. Defense counsel maintained that no one had been dodging or avoiding anything, and that her client had in fact been at every prior court hearing and every meeting she had requested of him. The prosecution then argued that Kaufman's failure to appear for the sentencing should be scored as 10 points under OV-19 in the sentencing guidelines, as that variable covers interference with the administration of justice and is not offense-specific, meaning any conduct up to the time of sentencing can be considered. Defense counsel objected to this, asking the court to disregard the request, and noting that the sentencing guidelines had been due for submission a week earlier. Yet this argument was being raised as though it were an emergency on the day of sentencing. The judge ultimately denied the request to adjust the OV-19 score and indicated the court will continue with the original guidelines. Defense counsel then raised a question of whether the sentencing should be adjourned in light of the fact that Kaufman was sitting before the court having suffered concussion that morning, which she stated was medically documented. She offered to approach the court with the documentation. The prosecution opposed an adjournment, arguing that Kaufman had admitted his crimes, was present to be sentenced, and would receive medical care through the Department of Corrections if needed. The prosecution also requested that the court take testimony from the defendant himself to establish whether he actually understood what was happening before granting any adjournment. The judge placed Kaufman under oath and asked him directly whether he was able to hear and understand everything that had occurred in court that day, and whether the injury to his head had caused him any difficulty in understanding the proceedings. Kaufman confirmed that he had been told he had a hematoma at the back of his head, but said he was able to understand what was going on. On that basis, the judge found no grounds to grant an adjournment and the sentencing proceeded. Defense counsel then addressed the court on her client's behalf. She began by stating that she had read every single victim letter submitted to the court and that she understood the position of the victims. She then turned to describe who Terry Kaufman was as a person. She noted that he was 72 years old with no prior criminal record, that he had buried 3 of his own children, that he held a high school diploma and had pursued advanced education, and that he had spent approximately 50 years providing funeral services to grieving families in his community. She described him as kind, considerate, soft-spoken, polite, and respectful, and said he had for many years been a well-respected citizen and businessman. She also pointed to letters in the record that described acts of kindness on his part, including shoveling a driveway in his advanced years so that a funeral could proceed. On the question of the money, defense counsel argued that the funds that had not been placed in escrow as required had instead been cycled back into the business, including to cover payroll. She described the funeral industry as one that had been changing and struggling, noting mergers in the region, and argued that the funeral home would have closed many years earlier had it not been for this flow of money. She maintained that during all of this time Kaufman had not been living extravagantly, pointing to the fact that he lived in a modest ranch house with a mortgage still outstanding. She argued that the funerals themselves had always been performed, and that the money had always gone to whatever funeral home was used, including in the case that had triggered the investigation. She described Kaufman as having been resigned and fully accepting of whatever sentence the court would impose, and said he had been cooperative, polite, respectful, and appropriate throughout his dealings with her. She also noted that when asked whether he wished to address the court, Kaufman chose not to speak in light of his no-contest plea and a pending civil lawsuit. The prosecution then addressed the court on behalf of the 55 victims in the case. The prosecutor noted that these victims were either legally incapacitated or developmentally disabled individuals who did not have the ability to care for themselves, and some lacked the ability to fully understand what had been done to them. He described how the money involved represented prepaid burial funds, much of which had come from government stimulus payments during the COVID-19 pandemic and had been carefully budgeted and set aside so that these individuals could live comfortably and be cared for. He stated that this money would never be replaced and that some of these individuals would never again have the means to fund another prepaid burial arrangement. The prosecutor then directly challenged several of the arguments made by the defense. On the question of Kaufman's lack of a prior criminal record, the prosecutor argued this was not a sign of good character, but simply reflected how long it had taken for him to be caught, given that he had admitted to 39 felonies, including criminal enterprise with predicate offenses spanning the last 10 years. On the claim that Kaufman had acted out of desire to keep the business open, the prosecutor pointed to bank account records showing that Kaufman had paid himself $1.5 million over the past 10 years and that this money had been moved into his personal accounts, including secret bank accounts that his own wife had not known existed. On the argument that Kaufman had always made sure funerals were performed even when the escrow money was gone, the prosecutor responded bluntly that of course he had, because the moment he failed to perform a funeral, the scheme would have been exposed, which is precisely what had happened. Someone had gone to have a funeral conducted at a different funeral home, and that home had discovered the money was gone, bringing the entire operation to light. The prosecutor also addressed the sentencing guidelines, arguing that they did not adequately capture the full scope of Kaufman's criminal conduct. He noted that Kaufman had scored 25 points under OV9 for having 20 victims, when he in fact had 55. He had scored 5 points under OV13 for 3 or more property crimes when he had admitted to 38 property crimes. And he had scored 10 points under OV16 for a loss of $20,000 or more when the actual loss exceeded $192,000, with total restitution obligations of over $1 million. On this basis, the prosecution requested that the court sentence Kaufman to at least the top of the guidelines, with count 1 running consecutively to counts 2 through 8, for a total combined sentence of 108 months or 9 years. The judge then addressed the courtroom. He acknowledged the number of people present and expressed respect for everyone in attendance, including any family or supporters of Kaufman. He emphasized that the court had to remain down the middle and consider the full picture. He spoke about the nature of what had been taken from the victims, describing how many of them had carefully planned and saved for their own funerals, specifically to spare their children and family members from having to bear that burden at an already painful time. He read from several of the victim letters submitted to the court, in which victims described trusting Kaufman completely and being devastated to learn their funds were gone. One victim wrote that they had given Kaufman a check for $6,691 and was angry that their prepaid funeral had been stolen. Another described giving $15,990 and receiving paperwork showing everything was in order, only to discover it was not. An elderly couple in their 70s and 80s described dealing with degenerative arthritis and memory difficulties, and said the stress of the situation had only made those conditions worse. A 94-year-old victim described having taken out a prepaid contract in 2016 for $10,000 that was now entirely gone. Another recalled receiving the signed contract with a handwritten note on the envelope from Kaufman, himself reading "You are all set," only to later learn that nothing had been properly secured. The judge read a letter from an elderly couple on a fixed income who said they had never met anyone of this nature before and had no reason to doubt Kaufman's word, and closed their letter by asking who they could trust, if not a professional neighbor,